Welcome back to the Mayor File. I'm your host. Today, we are opening a file that documents a shattering of the American legal norms so profound, so visceral, that it forces us to question the very stability of our judicial institutions. We are looking at an event that took place yesterday in a federal courtroom, an event that legal historians and constitutional scholars are already describing as a nadir in the history of presidential litigation. You have likely seen the headlines. You have heard the reports of shouting, of bailiffs moving in, of the physical removal of defense counsel. But headlines only tell you what happened. They rarely explain why it happened, or more importantly, what it signals about the strategy being deployed by the former President of the United States. This isn't just a story about a bad day in court. This is a story about the deliberate weaponization of chaos. It is a story about how the legal defense of Donald Trump has evolved, or devolved, from a strategy of delay into a strategy of destruction. We are going to analyze the meltdown involving attorneys Todd Blackburn and Jennifer Walsh before Judge Sarah Martinez, but we are going to go much deeper than the shouting match. We are going to look at the lineage of this behavior, tracing it back to the lessons Trump learned from Roy Cohn in the 1970s. We are going to examine the loyalty trap that has consumed the careers of Rudy Giuliani, John Eastman, and Sidney Powell. And we are going to look at the financial incentives, the dark money, and PAC funding that fuel this scorched earth litigation. This is an investigation into the collapse of courtroom decorum as a political tactic. To understand the gravity of seeing licensed federal attorneys escorted out by armed officers, we have to strip away the political noise and look at the mechanics of a federal trial. The courtroom is a controlled environment. It is designed to be the one place in America where rhetoric does not matter, where truth is determined by the federal rules of evidence, not by truth social posts. Judge Sarah Martinez is known as a jurist of immense patience and procedural rigor. For weeks, she had been managing a defense team that was testing every boundary. The issue at hand was the admissibility of evidence. In any trial, there are rules about what a jury can and cannot see. These rules exist to prevent prejudice, to ensure fairness, and to keep the trial focused on the actual charges. Judge Martinez had ruled, not once, not twice, but 3 separate times, that the specific evidence Blackburn wanted to introduce was inadmissible. In the legal world, when a judge rules, the debate is over. You preserve your objection for an appeal, and you move on. That is how the system functions. But yesterday, Todd Blackburn didn't move on. When he attempted to slide that evidence in through the back door during cross-examination, he wasn't making a legal error. Jane Mayer's analysis of similar past tactics suggests this was a calculated provocation. When the objection was sustained, Blackburn didn't pivot. He escalated. He challenged the judge's integrity directly. And when he uttered the phrase Kangaroo Court, he wasn't speaking to Judge Martinez. He was speaking to the cameras that he knew were waiting outside. He was speaking to the donor base. He was speaking to the client. The phrase Kangaroo Court is a specific trigger. It implies that the outcome is predetermined, that the judge is a political operative, and that the entire system is a sham. For a lawyer to say this inside the courtroom, on the record, is a professional death wish. It violates the most basic canons of legal ethics. It attacks the administration of justice itself. When Judge Martinez offered them an off-ramp, a chance to sit down, apologize, and proceed, she was offering them a lifeline for their careers. The fact that Blackburn and his co-counsel, Jennifer Walsh, rejected that lifeline is the key to understanding the current state of Trump's legal orbit. They chose the spectacle over the defense. They chose to be martyrs for the narrative rather than advocates for the client's acquittal. This brings us to the Roy Cohn Rule. To understand Blackburn and Walsh, you have to understand the man who created the mold, Roy Cohn. Jane Mayer has written extensively on Cohn's influence on Trump. Cohn, the ruthless attorney who served as Senator Joe McCarthy's hatchet man, taught Trump a simple lesson. Never admit defeat, never apologize, and always counterattack. Cohn viewed the law not as a set of rules to be followed, but as a weapon to be used to bludgeon opponents. He taught Trump that if you can't win on the merits, you destroy the legitimacy of the accuser. You destroy the legitimacy of the judge. You make the process so painful, so chaotic, and so expensive that the system breaks down. What we saw in Judge Martinez's courtroom was the ghost of Roy Cohn. It was the attack, attack, attack strategy applied to a federal criminal trial. However, there is a critical difference. Roy Cohn was, for all his flaws, a brilliant technician who knew how to manipulate the system from within. The current crop of attorneys surrounding the former president seems to have absorbed the aggression, but lost the technical competence. This is what we call the competence drain. Over the last 4 years, we have seen a mass exodus of top-tier legal talent from Trump's circle. The white shoe firms, the serious constitutional scholars, the experienced criminal defense experts, they have largely fled. They looked at the risks. They looked at the client's demands for total loyalty over legal reality. And they walked away. What is left is a different breed of lawyer. We are seeing attorneys who are often more interested in their proximity to power and their media profile than in their standing with the Bar Association. Todd Blackburn and Jennifer Walsh are now part of a growing fraternity of lawyers who have immolated their careers on the altar of MAGA. Look at the precedents. Look at Rudy Giuliani. Once the U.S. Attorney for the Southern District of New York, a man who took down the mob, a man who was knighted by the Queen. Today, he is disbarred, facing bankruptcy, and indicted. Why? Because he went into court and made arguments that had no basis in fact. He argued fraud without evidence. He confused the court of public opinion with a court of law. Look at John Eastman, a dean of a law school, a clerk for Clarence Thomas, a man with a sterling conservative legal pedigree. He concocted the legal theory that the vice president could unilaterally overturn an election. Now, he is fighting to stay out of prison and has lost his license to practice. Look at Sidney Powell, Jenna Ellis, Jeffrey Clark. The list is long, and the trajectory is identical. They enter the orbit, they adopt the scorched earth strategy, they cross ethical lines to please the client, and they end up facing the ruin of their professional lives. The incident with Judge Martinez is the logical endpoint of this trajectory. When you run out of legal arguments, all you have left is noise. The physical removal of counsel is the ultimate manifestation of a defense that has nothing left to say, but the system is rigged. But here is the tragedy that Jane Mayer's reporting helps us understand. This behavior hurts the client. A criminal trial is a delicate ecosystem. The jury is watching everything. They watch how the lawyers interact with the judge. They watch the body language. When a jury sees the defense team screaming, disrespecting the judge, and being dragged out by marshals, the inference they draw is not that the defendant is a victim of a conspiracy. The inference they draw is that the defense is desperate. They smell fear. They smell guilt. By engaging in these theatrics, Blackburn and Walsh may have solidified the loyalty of the base, but they have likely doomed the case. So why do they do it? If it's bad legal strategy, why is it the dominant strategy? This brings us to the financial infrastructure. We have to follow the money. Jane Mayer's work on dark money is essential here. The legal defense of Donald Trump is not being funded by Donald Trump. It is being funded by a complex network of leadership PACs, specifically the Save America PAC, which has burned through hundreds of millions of dollars in legal fees. This creates a perverse incentive structure. The lawyers are being paid by the political movement, not just the individual. Their audience is the donor class that keeps the PIs flush with cash. To keep the money flowing, the narrative of persecution must be maintained. If the lawyers went into court, followed the rules, played nice, and lost quietly, the fundraising emails would lose their punch. But lawyers dragged out of Kangaroo Court by deep state judges. That is a headline that raises $10 million in a weekend. The courtroom meltdown is, in a cynical sense, a fundraising asset. Furthermore, we must analyze the role of the Federalist Society and the broader conservative legal movement. For decades, the conservative legal project was about law and order, textualism, and respect for institutions. Figures like Antonin Scalia and Robert Bork were the icons. But the Trump era has fractured this movement. On one side, you have the institutionalists who are horrified by what happened in Judge Martinez's courtroom. They see it as a degradation of the rule of law. On the other side, you have the new populist wing, the MAGA law movement, which views the courts not as neutral arbiters but as battlefields in a culture war. Blackburn and Walsh represent this new wing. They believe that the old rules of decorum are tools of the establishment used to suppress the will of the people. When they shout at a judge, they are signaling to this new legal movement that they are warriors, not just lawyers. But let's look at the specific moment of the meltdown again. The reports indicate that after the Kangaroo Court comment, Judge Martinez went quiet. This is the judicial silence that precedes a storm. Experienced litigators know that when a federal judge stops shouting and starts whispering or goes ice cold, you are in the danger zone. Martinez asked a simple question. Do you understand what you just said? This was the final test. A competent lawyer, realizing they had snapped in the heat of the moment, would have immediately retreated. Your Honor, I apologize. Emotions are high. I withdraw the comment. That is the standard response. The fact that Blackburn doubled down, that he said, the exclusion of evidence proves it is rigged, shows that this was premeditated. You don't accidentally double down on a contempt charge. You do it because you have decided that the contempt charge is more valuable to you than the judge's goodwill. And then there is the intervention of Jennifer Walsh, the co-counsel standing up and screaming to the gallery. This tag team disruption is a tactic we have seen in political protests, but almost never in federal criminal defense. It suggests a lack of leadership control within the defense team. Who is in charge? Is it the lawyers, or is the client directing the strategy from the defense table? Reports suggest Trump sat silently during the exchange, watching. This is his management style. He pits his advisors against each other, demanding performative loyalty. He wants to see who is willing to jump on the grenade. Walsh saw Blackburn jumping, and she felt compelled to jump too. It is a competition for the favor of the defendant, played out at the expense of the court. The consequences of this are terrifying for the concept of a fair trial. The judge has now held them in contempt. They face sanctions, fines, and referral to the bar. But the immediate problem is the trial itself. Can these lawyers continue? If they come back tomorrow, the dynamic is poisoned. The judge cannot trust them to follow basic orders. Every objection will be viewed with suspicion. If they are removed from the case entirely, it creates a mistrial or a massive delay, which, ironically, might be exactly what the defense wants. Delay is a victory in the Trump playbook. If they can push the trial past the next election, the legal problems might disappear through the power of the pardon or the Department of Justice's policy against prosecuting a sitting president. Is it possible that the meltdown was a strategic attempt to force a mistrial? To make the situation so untenable that the judge has no choice but to halt the proceedings, buying months of time? It is a high-risk, high-reward gamble that only a desperate defense team would take. We also have to look at the reaction of the legal community. The shockwaves are real. Federal judges talk to each other. Prosecutors talk to each other. The reputation of these attorneys is incinerated, but more broadly, it creates a precedent that other judges will have to guard against. We are likely to see stricter gag orders, tighter controls on courtroom behavior, and perhaps more closed-door hearings to prevent exactly this kind of performative disruption. The Trump legal team is forcing the judiciary to become more opaque, which they will then use to argue that the system is hiding the truth. It is a perfect, self-fulfilling loop of conspiracy. Let's go deeper into the psychology of the Kangaroo Court accusation. In a functional democracy, the court is the one place where facts matter more than feelings. By attacking the legitimacy of the court, the defense is engaging in a form of institutional vandalism. They are trying to break the public's faith in the only mechanism we have for resolving disputes peacefully. If half the country believes the courts are kangaroo courts, then the verdicts they render are meaningless. This is the ultimate danger of the Trump strategy. It isn't just about keeping one man out of prison. It is about convincing millions of people that the prison system, the justice system, and the Constitution itself are all fraudulent. It is a strategy of delegitimization. And what about the jury? We cannot forget the 12 citizens in the box. They are not political operatives. They are regular people who were called to do a civic duty. They are watching highly paid, famous lawyers act like petulant children. The disrespect shown to Judge Martinez is also disrespect shown to the jury. It says, "We don't respect the process that you are a part of." Juries generally revere the judge. The judge is their guide, their protector, the neutral authority figure. When a lawyer attacks the judge, the jury usually takes the judge's side. The defense team has likely alienated the very people they need to convince. This disconnection between political optics and courtroom reality is the fatal flaw in the MAGA legal approach. What wins on Fox News often loses in the Southern District. The aftermath of the ejection was just as telling. The lawyers didn't go quietly to a holding cell to cool off. They went to the microphones. They spun the narrative immediately. We were silenced for fighting for the truth. The judge couldn't handle the evidence. This confirms that the audience was never the judge. The audience was the public. But legal experts know that appellate courts do not look kindly on this behavior. If Trump is convicted, and he appeals based on ineffective assistance of counsel or judicial bias, the appellate court will look at the transcript. They will see the insults. They will see the defiance, and they will likely rule that the wounds were self-inflicted. You cannot burn down the courtroom and then complain that you didn't get a fair hearing in the ashes. We must also consider the role of the bar associations. Being a lawyer is a privilege, not a right. It requires character and fitness. The state bars of New York, California, D.C., and others are currently investigating dozens of lawyers connected to the 2020 election subversion. This new incident adds fresh fuel to that fire. We are looking at a potential wave of disbarments that will decimate the ranks of conservative legal activists. Young law students are watching this. Are they learning that this is how you practice law? Or are they serving as a warning to the next generation? The legal profession is at a crossroads. If this behavior is normalized, the adversarial system becomes a shouting match. If it is punished, it reasserts the boundaries of professional conduct. There is a tragic irony here. Donald Trump often complains that he cannot get good lawyers. He blames the deep state for scaring them away. But the reality is that he consumes lawyers. He demands things that ethical lawyers cannot give, and he pushes unethical lawyers until they break the law and lose their licenses. The removal of Blackburn and Walsh is not an assassination by the state. It is a suicide by the defense. It is the inevitable result of a client who refuses to accept that the law applies to him. As we watch the fallout of this trial, we need to keep our eyes on the bigger picture. This isn't just about a single judge or a single defendant. It is about the stress test of the American Republic. The courts are the levees that hold back the floodwaters of chaos. Trump's strategy is to blow up the levees. By turning the courtroom into a circus, by provoking bailiffs, by screaming about kangaroo courts, His team is trying to drown the system in noise. They are betting that if they make the process ugly enough, the American people will tune out, or give up, or conclude that it's all just politics anyway. But here is the counter-argument. The system held. Judge Martinez held. She didn't scream back. She didn't lose her composure. She applied the rules. She issued the warnings. And when the line was crossed, she acted. The bailiffs did their job. The lawyers were removed. The trial, presumably, will continue. The machinery of justice is slow, and it is grinding, but it is built to withstand pressure. The spectacle of the ejection was shocking. Yes, but it was also a sign that the immune system of the court is working. It rejected the virus of disruption. In the coming days, we will see the contempt hearings. We will see if these lawyers are fined or jailed. We will see if Trump throws them under the bus, as he has done with so many before. I barely knew them, he might say. They were very excitable. The cycle will repeat. New lawyers will be found. They will be promised fame and fortune. They will be asked to cross the line. And eventually, they too may find themselves being escorted out of a side door, their careers in ruins, wondering if it was worth it. This is the state of the Trump defense in 2025. It is no longer a legal defense. It is a political insurgency waged inside the halls of justice. And like all insurgencies, it produces casualties. Yesterday, Todd Blackburn and Jennifer Walsh became the latest casualties. They fought the law, and the law won. The question remains, how much damage will they do to the institution before the final verdict is read? This file remains open. The implications of yesterday's events will ripple through every other pending case against the former president. Every other judge is now on high alert. The leash has been shortened. The tolerance for delay is gone. By going nuclear in Judge Martinez's court, the Trump team may have inadvertently disarmed themselves for the battles to come. They have shown their hand. They have shown that they have no cards left to play but chaos. And in a federal court, chaos is not a defense. Chaos is a conviction strategy. Thank you for listening to this analysis. We will continue to track the disciplinary proceedings against these attorneys and the progress of the trial itself. In a time of noise, we look for the signal. And the signal from yesterday is clear. The courts are under attack, but they are fighting back.